much. Of Bill Johnson. Good morning, everyone. Glad to see you here on this gorgeous September day. My name's Brian Riley. I'm a partner with KP Law, the town council. And we like to do these for our client towns, just kind of give, if you're new to this, maybe this is the first time you'll have heard some of this stuff. If you have been on a board or something for a long time, it'll be a refresher. But it is good to get a refresher on these sorts of things because these three laws, pretty much everybody always has to deal with, and there's always watchdogs out there to make sure you're doing everything right. So I'm going to sit here, but I'll be able to see you all. I'm going to go through these slides. Majority of them are about the open meeting law. It looked to me from the sign-in that you all sit on boards anyway, so definitely a good thing to know. And if you have any questions as we go, just put your hand up. I like to kind of take them as we go rather than hold them to the end. And let's see, I think that is about it. So legal disclaimer, we always like to throw those in. But it is, the purpose of this is I'm going to talk about these three laws and kind of do broad brush, sort of the basics. If an issue comes up under any of them, really, whatever the particular facts are can really change the outcome. You can go from, oh, you can't do that at all, to, oh, you can do that if you do A, B, and C. So, again, this is kind of general. I will take questions about specific things if you like. My job here is to sort of, do some training, not to find anybody guilty if they haven't been doing the right thing. Just to try to, clean things up going forward. And so these three laws, open meeting, public records, and conflict of interest, these are known as the sunshine laws. All the states have them. The purpose is that state government, for the most part, is also subject to them, but we're talking about local government, that the public is aware of what's going on. Open meeting law, you're required to do most of your meetings in public, and anyone who wants to can come sit and listen. Public records law, there's limited exemptions where you don't have to give a record out if somebody makes a request, but for the most part, they're all going to be available to the public. And then conflict of interest is there to make sure you're acting in the town's best interests and not yours. So we're going to start, as I say, this will be the bulk of it. The open meeting law is in Chapter 30A, Sections 18 to 23. And some of the things I'll cover include meeting notices. You may have a staff person that does this, or maybe your board chair does it. But the notices have to be posted in certain locations at certain times and have a certain level of detail in them. Meeting minutes, all boards, all public bodies that are subject to this law have to keep accurate and sufficient minutes. You never need to put down every little thing that everybody said, but there's got to be enough in there to make them useful to you, as well as let someone who wasn't at the meeting figure out what happened. And I'll talk a bit about what the Attorney General's position is on certain issues and the regulations that they have adopted to kind of fill in the gaps that the law doesn't quite answer. So some of the terms that are defined, meeting, kind of obvious. That's when a board gets together and you talk about things that are pending before you. You deliberate, you make decisions. It's not considered legally a meeting unless there's a quorum of your board present. So if you're a 5-member board and only 2 people show up, you really can't conduct your meeting. Obviously, you can't make any decisions. It's not a violation if you sit there and the 2 of you talk together, but it's not really binding, and you'd have to do it all over again anyway when you do have a quorum. The term is defined to have a few exceptions. First one is on-site inspections. This is very useful, especially for all the land use kind of boards, planning, zoning, conservation, Board of Health. People come in and they want you to give a permit to do something on their property. Well, maybe you'd like to take a look and walk around a little bit, see exactly what's being asked. A quorum or even your entire board can do that, and it's not considered a meeting. Obviously, on an actual meeting, the public has to be able to attend. If you're walking around on private property, that would be awkward. And so you're allowed to walk around, make observations, make notes for yourself, et cetera, but you can't then stand there on the property and start deliberating amongst yourselves. You need to try to avoid that, keep any questions or comments you might have, wait until your board is having a meeting where you can talk about it, and the public can attend as well. Sometimes a board will want to do a walkthrough and then immediately be able to talk about it, so you could do that. You could schedule a inspection of the site at 5 and have a meeting at 6. That would be the way you handle that. And another exception is that it's not considered a meeting if it's a public or private gathering, a social event, a training session or a conference. So this, for example, if a quorum of your board was sitting here, that doesn't make it an improper meeting. You're not here to do board business. You're here to, listen to the training, or you're at a birthday party or a reception or something. That's fine. Again, it says don't deliberate while you're doing that. As long as you don't, you're okay. And you can avoid, creating the appearance. If 3 out of 5 of you are at a party, maybe don't go in the next room and huddle together, because it's going to look like you're talking about board business. So just something to watch for. As I say, there's watchdogs out there watching your every move, as you know. Another exception is if you're at a properly posted meeting of another body. Maybe a development's been filed with the planning board. You sit on a board that might be interested in that, or might even be coming your way later. You can go sit in the audience with everybody else. You're welcome to ask questions, make comments, but you should treat it as though you're there yourself and not a board representative. And again, no deliberating if there happens to be a quorum of you present. Your board could schedule a meeting afterwards if you thought that was something you wanted to do. And sometimes 2 boards actually want to hold a regular meeting together. The select board and the finance committee may want to talk about the budget during the winter. They should both file it with the town clerk, both post their own agendas, and that way they can conduct the meeting together and make decisions and all that. But they do want to make sure that they've both posted properly. So deliberation is also defined. Oral or written communications, including email, between or among a quorum of a public body on any public business within its jurisdiction. And so, note that email because, again, it's not considered a meeting if there's not a quorum involved. A 7-member board, 3 members could be emailing each other about board business. That's not a violation, but as soon as a 4th suddenly gets on the string, that can be a problem. And also be careful not to exchange opinions. This is, also would apply over the phone or a meeting somewhere, but you don't want to exchange opinions between a quorum outside of a meeting. There are the exceptions, which the Attorney General's office, which runs this, the Division of Open Government is the office in the Attorney General's office that runs it. They're very strict on this point. Yes? Yeah, I'll give an example, and it may come up later too, but, as I say, these things are not considered improper for a quorum to be involved in. Distributing a meeting agenda, that might happen over email. If the chair is just trying to schedule a meeting, it's kind of administrative, that's not a problem. And then exchanging any reports or documents, again, email, this happens all the time. And so what I mean by that is, if let's say you get a report from an engineering consultant that your board wants to talk about, so the chair sends it out to everybody for the next meeting. That's fine. This is not considered deliberation. But if the chair sends it out and says, here's that consultant's report we were waiting for, we're going to talk about it on Tuesday, pay particular attention to pages 10 through 12 because I think he's missed the boat here and blah, blah, blah. That's expressing an opinion. And strictly speaking, that would be considered deliberation and supposed to happen during the meeting. And they will find, you know, if the AG looks at these and they find that sort of discussion or even one person exchanging an opinion to the rest of the board, they will say that's a violation. So that's what you need to be careful of. Yes, sir.
Just in terms of the documents, if a member sends a document around to other members of the committee, is that different from the chair? Does your admonition apply to the member as well as the chair of the committee?
It does. It does apply to anyone. And,
But,
I'm sorry.
Brian, that would imply that, you know, if I find a document of interest, that might be of interest to committee members, and I circulate it to the 7 members of the committee, and I'm not an officer of the committee, without any opinion, there wouldn't be anything wrong with that, would there?
correct.
Okay.
There would not be anything wrong with that. The only asterisk I would add to that is if what you sent around was a memo that you wrote up about why you're opposed to da-da-da, you know, then, well, you're sneaking in your opinions there. But you're right, if it's an article or a, you know, anything else, and you're just saying, I'd like to talk about this at the next meeting, that's fine, okay? So the statute specifically includes email. Emails is a great thing. It's very convenient for exchanging documents and keeping in touch and all of that. But again, you have to watch out for exchanging your opinions, your beliefs, how you're leaning on something that you need to take care of as a board. They also will, you know, not want to have a non-board member kind of try and end around. You know, the chair can't talk to the staff person and say, could you email everyone and see if they're yes or no on this? And then that gets back to the chair. You know, want to avoid that as well. Be careful with those reply to all buttons. You know, do try to, and this is what the Attorney General says, you really should limit email to scheduling or sending around agendas or other documents for the meeting. So that's, you know, not only can you all of a sudden have a quorum involved, even inadvertently, but you know, email gets available. It may show up in the newspaper the next week. So just try to keep that in mind anytime you use email for board business. Same applies to social media. There's not a lot. The Attorney General hasn't done a lot with this, but you know, as you can imagine, hopefully you wouldn't be using Facebook to the extent you use it anyway for talking about board business. But if you posted something and a quorum of members threw in a comment on it, that to me, I think the AG would say, well, that's the same as email. You did that, and you know, maybe it's available to your friends, but again, that you know, kind of violates the thing where any of that sort of exchange of opinions is supposed to happen in a posted meeting. So again, this is just sort of expounding on that point. All right, so the open meeting law applies to any public body. So it's basically any multi-member board. It does not apply to a single official, superintendent of the schools, town manager, building inspector. They're not subject to the open meeting law, but any multiple member board, committee, or subcommittee, you know, of the town, however created, elected, appointed, or otherwise constituted, that's established to serve a public purpose. And so a couple of things that is notable for is that it does include subcommittees, and it's not strictly defined what's a subcommittee versus what's not. What I usually tell people is if, you know, 5-member board, 2 members meet at the supermarket on a Saturday, and they say, you know, I think we need to, I'd like to, you know, bring to the board's attention at our next meeting something. If the 2 of you sit down and work on something and then report back at the board the next meeting, that's really not a subcommittee. You weren't designated to do something. You weren't in charge of this. But if the same 5-member board delegates a task to 2 members, and the 2 members are supposed to come back, then I think the AG would say that's a subcommittee, if you sort of formally created. And it doesn't matter if the subcommittee has members of the parent body or if it's, you know, completely different. Odds are they're going to be subject to the open meeting law. The AG looks at it and says, well, is it within government? So again, like the subcommittee example, you're delegated for some task for a town board, you know, that's within government. If it's a committee set up by the Chamber of Commerce to talk about streets or parking or something, you know, that's sort of a public issue, but that would not be a public body, I would say. And if you're empowered to act collectively, in other words, you're kind of working towards making a decision or recommendation, that's going to make you look like a subcommittee and serving a public purpose. Let's see. So subcommittees, yeah, it does say the intent to create a subcommittee, not necessarily required, but as I say, if this is kind of a random get-together of something less than a quorum, I don't think that would be found to be a subcommittee, but it does not have to be a particularly formal creation. Kind of depends on how it came to be. There is one interesting exception, which comes from a appeals court case, actually about 30 years old now, this Connolly versus somebody or other. This was a case where a superintendent of schools, single officer, not subject to the law, wanted to find a new principal, and he appointed a little committee to kind of help him decide, well, what are we looking for in a principal? You know, who's put together a, you know, an advertisement perhaps. Someone complained about it, went all the way to the appeals court, and the appeals court said, we don't think that group was subject to the open meeting law. That was a decision that this single officer, who's exempt, could have made on his own. He decided to get some help, but that's a committee of that officer, not really a committee of the town, and therefore they said, not subject to the open meeting law. When the Attorney General was given kind of full reign over this law about 9 years ago, they considered this and they thought, well, that's still good law to us. But that's really the only exception where a group is going to be exempt. Scheduling meetings. You need to, you know, you need to put the location of the meeting in the notice, of course. You need to watch that it's an accessible location. It's a requirement of the open meeting law as well as the federal Americans with Disabilities Act that public things are accessible to the public. Yes?
I'm sorry, can we back up 1 second?
Yeah.
I think I missed something. A subcommittee created by the chairman of a body to do a particular task, like study a particular thing.
Right.
About the street. And it's 2 or 3 people. I'm not clear about whether that becomes a Connolly committee or something that has to have a public notice if it's going to go out and inspect whatever it has to inspect.
I'd say that the Connolly rule, so to speak, is really if the responsibility lies with one person to make a decision. If they want to create a little subcommittee to help them make that decision, that group would be exempt.
What if the overall commission is going to end up making a recommendation, but not all 7 of them have the time to study this particular thing?
But if let's say the chair, you know, realizes that that's the case and says, well, I'd like to have 3 of you who are available to do it, it's still something where the parent body, I'll call them, is, you know, they're the ones who ultimately need to do something with this information. So I'd say that is a subcommittee under the open meeting law. So they need to post and they need to keep minutes.
So that means if that subcommittee is going to go and inspect whatever it has to inspect, there has to be a notice of it?
If that's all they're doing is, you know, walking the property, like I said earlier, that's not considered a meeting. But if they're going to sit down and go over notes and try to figure out what the recommendation's going to be, I would say they need to post that. I know, I'm full of good news this morning, right?
Connolly was a group of people, but not necessarily members of a board, just like citizens that came in and just helped.
Right, yeah, the Connolly rule is just if it's a single officer who has this decision to make and they want to appoint a group to help with that,
Right. So-
they're not covered. But if it's a board that needs to make a decision and they want a group to help them make that, that's going to be a subcommittee. Okay? Accessibility, it is, oh, sure.
the information but not making a recommendation. So the subcommittee to look at roundabouts or something else. It was just collecting potential designs that the full committee will talk about in the meeting and decide, make a decision on what to recommend. Would that be a meeting, or is that just simply we're sitting around and looking at different designs and putting together a list of designs, not making any decisions or recommendations?
It's, again, I think it sort of matters how that group who's just doing that came to be. I think if at a meeting of the whole board, the chair said, or a vote was taken, maybe, we need to get a small group together to put together these plans and give us the best one, I think that's probably going to be considered a subcommittee. If you do it on your own, then maybe you're not. All right. You can't, oh, sure.
I personally think it's better to be safe than sorry.
That's, I would, yeah,
You know,
yeah,
for the airport, we posted a lot of meetings when we're not even sure that, more than two are gonna be there. Just
right.
Cover and not.
Yeah,
make a mistake.
if you don't have a quorum show up, well, at least you're not in violation.
It's
Yeah,
posted.
right, exactly. Yep, that's good
And that's why
advice.
All these meetings have to be posted, if it is any part of a board.
Right, that's right. You can have a meeting at a private location, a private building, that's okay, as long as whoever owns that understands that the public has to be allowed to come in. Sometimes you need to move a meeting, you realize there's gonna be more people showing up than you have seats. The power got knocked out in one building and you wanna move it somewhere else. You can do that, even sort of last minute, just do what you can to, post it on the website if you can, that there's been a change, put a notice on the door of the first location as to where you're gonna be. It's not ideal, you may decide it's just better to cancel and try again, but you can do that. And it's okay to have an open meeting with the doors closed. Maybe you want to keep out noise or air conditioning or whatever it might be, but just it's important that the public that's showing up understands that they can open the door and come in. That's all that means. So the post.
Location change can be made without the 48-hour notice by putting post.
It could be, if there's a good reason for it, yes. So the posting requires 48 hours in advance of your meeting. But that you can't count Saturdays, Sundays, and legal holidays unless it's an emergency. I'll talk briefly about that. So whoever's in charge of, filing your notices with the town clerk and making sure they get on the website needs to always keep that calendar in mind. If it's a Monday night meeting, it needs to be posted by the end of the day Thursday. If there's a holiday in there, you got to bump it out again. Notices must include the date and time of the meeting, as well as the location, and some kind of record of the date and time that the notices were posted. People do complain about that. They say, I don't think you made the 48 hours, so I'm filing a complaint. I think you violated the law, like that. Well, if you filed it with the town clerk, usually they will date stamp it. If it gets posted on the website, there's a record of when that got posted as well. So that's very important to respond to that kind of complaint. And if it gets revised, sort of late added agenda items, something that comes up the day before, which the chair putting the agenda together didn't anticipate, you can add that. The Attorney General advises that if you're going to revise your agenda like that, post the revised agenda as soon as you can, and have the original one available as well so people can see that there's been a change made. Now, where do they get posted? As I said, the law requires that it gets filed with the town clerk. That can be done by email, which again gives you a date and time. But it does have to go to the town clerk's office and then get posted in a manner that's accessible to people at all hours. The law itself says in, on, or near the municipal building which houses the town clerk's office. After a while, the Attorney General realized that most people wanted to make the website their formal posting, which it is available 24 hours. Initially, they were kind of reluctant to do that because not everybody, does have access to the internet. But they finally decided that enough people do that would be okay. And so in order to do that, the chief executive officer, the select board, needs to approve that is the formal 24-hour location. There should be a notice at town hall where the clerk's office is that says, if you want to, see the upcoming notices, this is the website address. And in a regulation recently, the AG added that if that is your formal posting and the website crashes for some reason, some catastrophic thing happens, and you can't get at it, if that happens within 48 hours of the meeting occurring, not including weekends, and the website doesn't get restored within 6 hours, the regulation says you have to reschedule your meeting. I haven't really come across that happening, but that's what it says. So if for some reason the day before your meeting the website's down all day, the AG is going to tell you, well, then you need to repost the meeting and start over. So the notice itself, date, time, and place, and listing of topics that the chair reasonably anticipates will be discussed at the meeting. So, this is important because, you may have 10 things on the agenda. If the chair or whoever is putting it together forgets to add something that was intended to be discussed, I always say you got to put that off to the next meeting because you can't say that was not reasonably anticipated. As I say, you can deal with a kind of a late added thing which nobody knew was coming until the day before. The list should have sufficient specificity to advise the public of the issues that are coming up. So there's a lot of examples of that. The AG will say, well, don't just put, license renewals or, alcoholic beverages application. You want to put in, names, locations, maybe whether there's going to be a vote taken, something that gives the public enough information so they can look at that and say, oh, I am interested in that item. I'm going to try to come to that. And let's see. Yeah, avoiding general topics. Should be some detail. Okay. Other advice which has come out of these formal determinations that the Attorney General has issued, avoid using acronyms. Your board may be involved with housing, housing authority or something, and you may deal all the time with HUD's CPD home program. Well, not everybody sitting at home has any idea what that is. So better to spell it out so at least they either know what it is or they can go look it up if they're still not sure. Another, conservation commissions have lots of acronyms they use. Again, better to put out order of conditions, not OOC, which is the one they use to themselves. If you're intending to have an executive session, I'm going to cover those, what those are. That needs to be listed on the agenda. You want to cite, what purpose that's that allows the executive session to take place, and some information about what exactly you're talking about. Just saying it's a personnel issue, just saying union contract negotiations. Again, that's not enough information. You need to put what union you're going to be talking about. And the AG said sometimes a board will have a special meeting just to do an executive session. Maybe they're meeting with someone from my office to talk about an ongoing court case. That's the only thing they're going to do. Boards typically would just put that, one item on the agenda. The Attorney General got a complaint and said, well, if you're going to do that, you should still have two items. One, open and open session, and two, executive session. If before you have executive session, you always have to open and vote to go in. You need a majority vote of your board to go into executive session. So the AG said, well, the public should know that they have a right to be there, even though we may be talking about 30 seconds of open session time. So if you do get, you've got a meeting, it's been posted 48 hours ahead, the day before something comes up. Maybe you got a a decision in a court case that you want to talk about. Maybe there's been some, incident with the, sewer or water in town that you want to talk about, but you're within the 48 hours. As long as it's not reasonably anticipated as an agenda item, it can be added. You'll want to update, again, on the website as best you can. And they can be discussed and acted on. The Attorney General always says, well, that's not, because it wasn't reasonably anticipated, it's not a violation that you talked about that. But we do always encourage boards to put those kinds of things off to the next regularly posted meeting, just so everybody can learn about it. But it's not a violation to deal with it. Emergencies, the Attorney General will basically say, we think the only thing that makes an emergency meeting, in other words, scheduling it and meeting it in less than 48 hours, is some sort of public health or safety issue. Just because it's some matter you meant to work on and forgot to put it on the last meeting agenda, that does not make it an emergency. But if there's some incident or a blizzard is all of a sudden scheduled for the next day, maybe the select board wants to meet with the DPW superintendent and talk about, well, this is what we should do, maybe we should close these streets, that kind of thing. That obviously has public health and safety issues. Right now, up near where I live, outside of Boston, there are several towns which are dealing with eastern equine encephalitis, with mosquitoes. And so I know of at least a few of them, the Board of Health has had an emergency meeting to talk about it. I'm sure the AG is not going to have any trouble with that. But it really does need to be that kind of thing. If you do happen to have an emergency meeting, follow the law as best you can, post it when you can. Don't talk about anything other than what the emergency is. Don't kind of slide in any other business. Take minutes, approve the minutes, at a future regular meeting. And then you should be fine. Yes?
I just had a question, just to make sure I understood. So at board meetings where the board may be asked, does anyone have anything new they'd like to discuss, any new items to bring up? That's fine if they weren't on the agenda, as long as decisions aren't made. Is that right?
Well, you actually could even, if it wasn't anticipated, you could even make a decision. And you're right, you could say, does anybody in the public have anything they want to talk about? Somebody could get up and say, there's this terrible pothole that just collapsed in front of my street. Well, maybe the board wants to say, okay, we're going to call a DPW and have them take care of that right away. All in favor? That's fine, because it was not an anticipated matter. That one I don't think the AG would say you should have put it off, but just if somebody raises something that may be sort of broader interest, the Attorney General would say, it's okay that you dealt with that and made a decision, but, always think about maybe putting it off so people can come the next one, that sort of thing. The law, when it was rewritten, again, 8 or 9 years ago, put in something about recordings. As you know, a lot of meetings, more and more, are kind of broadcast on cable now, so people probably know that when they walk in that there's being recorded. But the law says that if someone in the audience wants to come in and make their own recording, audio or video, it's an open session. They're allowed to do that. You have to allow them to do that. But there is a criminal statute which says it's illegal to record someone without their knowledge. There's sort of wiretap statute. So the law addressed that by saying, well, if somebody wants to make a recording of the meeting, they should come inform the chair, and the chair should make an announcement. So at least those who were in the room at the time won't be surprised later that, oh, I didn't know I was being recorded when I got up and talked. If somebody does come in, particularly if they want to video the meeting, the chair can say, you can do that, but please keep it off to the side so you're not interfering with, the view from the audience, that sort of thing. But again, you can't tell them that they can't do it. That has happened before, and it leads to messy First Amendment lawsuits and all sorts of things you want to avoid. Conducting meetings. This is more sort of practical rather than necessarily legal parts of the law. The law does say that no one is entitled to address a public body unless recognized by the chair to do so. So a lot of boards like to have a public comment period at the beginning or at the end. You know, it's really up to you, but you're not required to. Executive sessions, which I'll get to shortly, is the few times where you actually are allowed to keep the public out. You can decide if you're going to have public comment or take questions from the audience, anything like that. You can decide when you're going to do it, if you're going to do it at all. You do want to be careful. You know, if somebody gets up and is very upset about something, you know, you don't want to get into a debate either between people in the audience or board members and them. You know, we typically recommend, well, you know, hear what people have to say, and then you can decide later if it's something you want to add as a agenda item. You know, try to keep control of the meeting. If you've got one of those meetings with a controversial issue and 75 people show up and half of them want to talk, you can say, you know, we're going to take public comment, but please limit to 2 minutes each. That's one way you can sort of keep things in control. Remote participation. This is a part of the law where given modern technology, a board member may not be able to attend, but still wants to participate if they can. They can do that as long as the local select board or mayor, in case of a city, has approved it, and then it's available to boards. But there are a lot of rules about it. A quorum of the board always has to be physically present. You can't have 3 members out of a 5-member board not there and try to do this meeting. Whoever's chairing the meeting has to be physically present. Anyone participating remotely, whether it's over a conference call, you know, a speakerphone or Skype or anything like that, they obviously need to be able to hear what's been going on, but also the audience needs to be able to hear them if they're talking. You can't sort of have the chair sitting there talking to the member and then saying what they said. It's got to be available. If a member is doing this, all votes have to be recorded as roll call. The chair is supposed to announce, you know, why this is happening and the way it's going to be handled. And the member is only supposed to do this if attending would be unreasonably difficult. It doesn't necessarily mean that they're, you know, laid up at home with a broken leg. They could be in New York on business or something. But you know, you're not supposed to do it just because you don't feel like coming in, if there's some reason why you can't make it. If a person is participating remotely, they are considered present. They're allowed to vote and participate in the debate and all of that. Okay, executive sessions. So as I said, this is when, oh, yep.
Can I ask a question? On the remotely, is there a limit or a number that you can, of your meetings, be there remotely?
The statute doesn't really, statute just says this will be allowed if allowed by the Attorney General by regulation. And the AG does have some regulations. It doesn't address that. They do say, however, that a municipality can adopt their own restrictions as long as they don't conflict with the AG. That's about the only one that I have seen. You know, members can participate remotely no more than, you know, 4 times a year or something. I'm not sure. I think the select board actually might have something along those lines, but yeah. So that can be adopted as a local rule. Again, the executive authority kind of decides whether this is allowed and if there's any kind of restrictions like that. So with executive sessions, as I say, this is when you can actually have a meeting just as a board and keep the public out. You have to open an open session and vote to go in. The chair or in the motion should state subjects that may be revealed without compromising the purpose for the executive session. The vote to go in has to be recorded in the minutes as a roll call. The chair will always want to announce whether you're going to go in executive session and then come back and finish your open matters, or if you're going to go into executive session and adjourn at the end. That way people aren't sitting around waiting. Just like when open session, all exhibits and documents used have to be kept. Only discuss the matters cited. That's an important one. If you're going in to talk about litigation strategy over a court case, It's real easy for a board to kind of slide into some other topic. Strictly speaking, that's a violation. And all votes have to, in and during the executive session, are also roll call. The statute provides 10 different purposes, but really these 4 are the ones that come up 90% of the time. The first one is usually to deal with sort of labor, personnel issues, to talk about the reputation, character, physical condition, or mental health of an individual. You know, there may be some employee that you have a concern about their physical condition. Obviously, you don't want to do that sort of conversation in open, so you can do that. Rather than professional competence, that is there because if a board's going to do an annual review, performance review of someone that they oversee, that has to be done in open session. Or to discuss discipline or dismissal or hear complaints or charges brought against a public officer or employee. Again, sort of labor issues. You get a complaint, maybe it's serious, about a town employee. Again, that kind of thing, obviously good reasons to do that behind closed doors. If you're going to use Purpose 1, you always have to give 48 hours written notice to the individual that you're going to talk about. They are entitled to come. They don't have to. You could still hold it as long as you gave them notice. But you have to tell them they could come. They can bring an attorney if they want to. They can make their own recording of that executive session if they want to. You also don't need to give the name of the employee who got the complaint filed against them. Yes?
So, the reason in that case for going into executive session would be what, to discuss
You could just,
personnel matter?
yeah, you could just say, you know, executive session under Purpose 1 to hear a complaint brought against a public employee, something like that.
Or if it's a board member, public individual?
Yeah, right. As I say, on some of these other ones, you're supposed to give a little more information about, well, what union are you talking about? What piece of property are you talking about? But for Purpose 1, it's okay to leave the names of the individuals off. Number 2 is conduct strategy sessions to prepare for negotiations with non-union personnel. So if you're a board that does, you know, hire people or appoint department heads, that kind of thing, you can meet privately as a board to talk about your contract strategy, or to actually conduct collective bargaining sessions or negotiations with those non-union personnel. In that case, the union rep or the employee is in there with you. That can also be done in executive session. Number 3 is strategy with collective bargaining. So again, you don't have the union in there in the room for that time, or for litigation. If an open meeting will have a detrimental effect on the bargaining or litigating position of the body and the chair so declares. To a recent complaint, the Attorney General said, well, the statute says that, and so the chair is supposed to make that declaration. So either as, again, part of the motion to go in, or the chair could just say this, you know, we're going to executive session to talk strategy with regard to collective bargaining with the police and fire unions, and we believe doing it in open would have a detrimental effect on our bargaining position. That's supposed to be stated before the board actually goes in and excludes the public. Similarly, number 6 has to do with real property. You know, maybe a school department or the select board want to talk about a piece of property that maybe the town might want to purchase, a piece of town property that maybe they want to sell. You might want to go in and talk about, well, what would be our asking price, or what would be the limit of what we would recommend at town meeting if we want to buy this. You don't want to do that in open session. You're kind of tipping your hand on what your limits are. But again, you should say the chair is supposed to declare that doing this under Purpose 6 would have a detrimental effect on our negotiating position. A few practical things with executives is, again, if you anticipate having it, needs to be on your agenda, your meeting notice. As much specificity as possible without compromising your purpose. As I said, if the board's going to do collective bargaining discussions, they want to list the unions they're going to talk about. If it's ongoing litigation, You want to say, we're going to talk about the case of Johnson versus Planning Board, not just litigation strategy, put that in there. You can still have that, out of the public view, but the Attorney General has said that, the public has a right to know that this is an ongoing case and the board is, dealing with it. And so that information needs to be included. Let's see. Okay, I've gone over that second one. Did you? Oh, yeah.
Just back to the real estate, is it required to identify the property, or could the board just say, real estate matters, and that could cover who knows what?
It kind of depends if, it kind of depends on what stage you're at. If even revealing, the address of the property would have a detrimental effect on your, negotiating position, you don't have to name it. But there has been a couple of determinations from the AG that say, well, that makes sense at the beginning, but, by the fourth executive session you had, it was already known on the street that you were interested in this property. You can still go in and talk about it privately, but at that point you should have put, 25 Poplar Street. So that's kind of how that plays.
Just a follow, is the same thing true of the legal matters? The town might be involved with 100 different legal matters.
Yeah.
And do they have to identify that there's been a letter received, that they're gonna be sued, or how, and then you have to identify the case, or can you just say legal strategy?
Let's see. Well, I guess there's a couple things there. First of all, you might have a matter where the town, if legal action is going to be taken, the town will be the plaintiff, some kind of enforcement action. I think there's a very good reason not to put that out there. So there, I think you could, to discuss litigation strategy and not put the identifier in. If somebody complained about it, we could explain to the Attorney General, this was an enforcement case, we weren't sure what we were going to do, and we didn't want to put that out there. If you get you get a letter from someone's attorney saying, if you could go forward with this, we're going to be filing suit next week, you can do executive session with that. The letter itself would be a public record, so I don't think you'd necessarily gaining anything by not including the name, but again, if challenged, you'd need to say, well, we didn't put the name in because we felt this would hurt our position because of X, Y, and Z.
Just to follow up, Brian, if such a letter had been written, the public wouldn't necessarily know unless there was a public document filing folder that all such documents were available in someone would it every day,
Yeah. Yeah, that's a fair point, but I'm just saying, if you don't list the name of, if you don't identify who's making this threatened litigation against you, you just have to have a good reason, that's all. Okay? Sure. Okay, we covered that. Meeting minutes, also an important aspect of the law here. They need to have the date, time, the place, the members of the board who were there, a detailed summary of the discussion of each topic. Taking minutes is kind of an art. You don't want to have everything everybody said, but you also can't have an hour of discussion and 2 sentences on what was discussed. There needs to be enough detail there, so going back, someone who wasn't there can sort of get the gist of what happened. All decisions made, all votes taken need to be recorded in the minutes. Boards can't have secret ballots. You need to list the documents that were used at the meeting. That's supposed to be recorded in the minutes. The documents used aren't technically part of the minutes, but this list is supposed to be there. And a document that was used at the meeting, quote unquote, is if the document was there, the board members had it in front of them, it was identified during the meeting, and the contents were discussed. If all those 3 things happened, then that needs to appear in the minutes list. Minutes need to be approved. You want to have, a final set of minutes as opposed to maybe the 2 or 3 drafts that led up to it. And so you want to stay on top of those. The statute just says they should be approved in a timely manner, and so that led to a lot of debate over what that really means. The Attorney General came out with a regulation a couple of years ago saying we interpret that as approving minutes either by the third meeting afterwards or 30 days, whichever is later. So if you meet every week, that gives you 3 weeks. If you meet every 2 weeks, you get 6 weeks. And if you don't have them approved within that time frame, and someone complains about it, you need to have some sort of good faith reason. Maybe your staff person abruptly quit and you didn't have anyone to type them up for a couple of weeks, something along those lines. Minutes are public records at the moment of their creation. What that means, this is really a public records law issue more than open meeting, but if you hold a meeting and you've got someone there who's in charge of the minutes, maybe they're taking handwritten notes, typing it on their iPad, or making a audio recording to use to type up later, that they become a public record, if it's an open session anyway, right off the bat. Somebody could come in and I want a request of those draft minutes, or I want to make a copy of that recording. They're entitled to get that. You can charge them for, making a copy of a tape, that sort of thing. But they are public and available. And so if somebody makes a request like that, you have to honor it. Once the minutes have been approved, boards voted the final version and going to put them on file. If no one has made a request for drafts at that point, you can actually get rid of them. You can use the tape over again. So it depends if anybody has asked or not. Approving minutes, the same holds really for executive sessions as well. Obviously, people aren't going to know that you have discussed and approved them, but it's better to stay on top, for practical reasons too. If you've got an executive session about a court case and it went on for 2 years, it's hard to look back at minutes from 2 years ago and see if they're accurate or not. So you really should also keep up with that, 30 days or so. It says the chair is obligated to review them. The chair could allow somebody else to do it as well. And they can be approved in executive session because they're still considered covered at that point. Once they have been approved, they're going to be available as a public record unless there's parts of them which can be taken out. Attorney-client privilege discussions. Maybe you were talking about somebody's medical or criminal records. Those can be taken out of the minutes, but otherwise they're going to be available. Yes?
Are there some timelines that the board would have to follow for releasing executive session minutes? I mean, maybe they're 10 years old by now. You think the issue is long gone, but they still haven't released minutes.
Yeah, the rule is that executive session minutes can be withheld, even if somebody asks for them, as long as the purpose of the executive session is continuing. So I'll use litigation again as an example. It may drag on for 2 years. Finally, the decision's made. Nobody filed an appeal. The 30 days are done. So that case is done. At that point, you can't sort of point to the open meeting law and say we don't have to make those available. You don't have to release them in the sense of announcing at a meeting, these are now all available, but they have to be available if anybody asks for them at that point. So it really depends on how, and certain personnel issues, the purpose for keeping those secret really is never going to go away. So there's no hard and fast timeline now. Yes?
I don't know if this question is appropriate right now, but
Mhm.
is there any rule about boards that always meet together?
I'm sorry?
Boards of note-taking, boards that always, two different boards that always meet together at the same time?
Well, you could either have someone from each board or a staff person be in charge of creating their own minutes, or if they hold a joint meeting together and have one person create the minutes, I would advise that both boards vote to approve, the final version. But I think that would still comply. if you had a single set, as long as they both approved. Yes?
An earlier slide we had, that any documents used in the meeting need to be listed.
Mm-hmm.
If someone were to go and get the minutes from that meeting, with the copies of the actual documents needed to include, it's not hard to understand if you don't see the documents.
Right, well, they don't have to be attached to the minute, they're not really considered part of the minutes. But the idea is that if they look at the minutes and they say, oh, we got this, engineering report from Weston and Sampson, I'd like to take a look at that. Well, now they can make a records request to find that, because it's still going to be subject to the retention schedule under the open meeting law, the public records law. Okay? You don't necessarily have to keep in the same folder. I mean, maybe that'll be easy, or maybe that would make your filing cabinet out of control. It depends. The enforcement process, if someone thinks that a board has violated the open meeting law, they can file a complaint. They are required to do it within 30 days of when they think the violation happened. And it gets filed with the public body that they're complaining about. That public body has 14 business days, so it's almost 3 weeks, to react to that and issues some kind of written response. My office often will draft up a response that we think, covers the complaint, or a board can do it themselves, but you have to watch for that 14 business days. If the person who filed the complaint either disagrees with the board's response, or 30 days have gone by and they didn't get a response, they can file with the Division of Open Government and say, I think this board violated the open meeting law, I want you to look into it. And they will. So let's see. So the AG recently listed what they want to see a public body do when you get one of these written complaints. Put it on your meeting notice. Again, this is a particular agenda item that you're going to deal with, so put it on your agenda item. Discuss open meeting law complaint filed by so-and-so. You want to, at the meeting, acknowledge receipt of the complaint. You talk about what the allegations are. Do we agree that the meeting didn't get posted on time? Do we agree that the executive session was for an improper purpose? A lot of times you don't agree, and that can be your response. We deny that there was a violation, and here's why. And just kind of decide how you're going to resolve it, whether you're approving a draft response that I may have written, or coming up with your own. 14 business days, I say it's almost 3 weeks. Occasionally that's not going to be enough time. Maybe you only meet every 2 or 3 weeks. You can ask the Division of Open Government, say, this is due by a certain date. We're not going to be meeting until a week later. Can we have an extension? And as long as you ask ahead of time, they'll always say yes. The response gets filed with the division as well as the person who filed the complaint. Occasionally you get a complaint and you agree, we didn't get our minutes approved on time, or we find that it actually wasn't posted until 24 hours before. If you kind of admit that and say what you've done to cure it, because of that, we are going to relist these agenda items and talk about them at the next meeting and kind of cure the fact that the original notice wasn't good enough. The AG likes to see that. They want to see you be proactive if there was a mistake, and they're not going to hold it against you so much. So that's a good way to deal with that if you find that there was some sort of inadvertent mistake or violation. If the AG looks into it, if they get these complaints, they may contact your office saying, can we get the minutes from the meeting that's being complained about? Can we get copies of your notices to prove it was posted on time? If they do find that there was a violation, usually if it's sort of relatively minor, you talked about something which wasn't on the agenda, you're liable to get a letter that says, this was a violation, be sure you comply with this going forward, and that would be the end of it. They can require a board to attend a training session. That office goes around and gives sort of regional training sessions like this, but they'll also accept it if a town council provided it. If it's a board that hasn't done any minutes in 6 months, and that does happen, they will say, you've got to go back and do the best you can to create these minutes. We want to see you do that, in the next month. So that's can happen. Nullifying an action taken if there was a serious violation involved. They can impose a $1,000 fine, up to a $1,000 fine against the board. It's not the individual members who have to pay that. It's really against the town. But that's for an intentional violation. And so it doesn't happen that much, but the Attorney General would, this Division of Open Government would decide they think it was an intentional violation. The board knew they were doing it wrong and did it anyway. Or maybe they've been warned 3 times and they did it a 4th. And there also is this sort of administrative hearing session with a retired judge. And if all that happens and they say, yes, this was an intentional violation, then they can impose a fine. The public body, if they disagree with a decision, can appeal to Superior Court. That's expensive and it takes a long time. It's usually not going to be worth it. The Attorney General can take enforcement action against the board, particularly if they think they keep doing the same violation over and over again. Or 3 registered voters can file a complaint against the board under the open meeting law. Again, that's expensive and takes time. Most people, if they think a board did something wrong, they should just do this written complaint process. Some of the regs that were recently amended, one was approving the website again as the all hours location. As I mentioned, if the website crashes, you got to be aware of this 6-hour business. Certifications, if you are new to a board, someone, usually the town clerk's office, sees that you have received a copy of the law, the regulations, the Attorney General's open meeting law guide. It's on their website. You may have been handed that, which includes the law and the regs as well. It's a pretty useful summary, actually. But the regulation also says that a new member should receive a copy of any determinations from the Division of Open Government that found a violation of that board within the last 5 years. It doesn't really explain whose shoulders that responsibility to do that lies. But the reason for putting that in there is if you get appointed to a board, you find out, oh, they were found in violation of not keeping minutes, within the last 5 years. I should be aware of that. I should maybe encourage us to keep up on our minutes so we don't violate it again and maybe risk being found to be an intentional violation. Filing complaints on the division's website, they have a complaint form. It's about 3 pages long. A person filing a complaint has to use that. If somebody makes a complaint by a letter or email, the regulations now say the board does not need to address that unless it's on this official form. For a serial complainant, five or more in the last 12 months, and they're out there too, as you may know. The regulation says that there can be a mediation between the public body and that individual. The downside is the town has to pay the cost of that. You have to actually hire someone who is a professional mediator. And really the only benefit to that is if you say you want to do mediation and the person says, no, I'm not going to do it. If they then file number 6 complaints and it goes to the Attorney General, if you tell the AG we offered mediation and they said no, then the Attorney General is going to say, well, then I'm not going to look into your complaint. That defeats the purpose of this whole mediation option. And that the public body needs to consider the complaint at a meeting. You can't actually do it in executive session because, strictly speaking, it's a complaint against a public official under Purpose 1. I usually advise against that because it kind of makes it look like you're hiding something. But it is possible. If the AG orders you to do something, such as have a training session, get all up to date with all the minutes you're missing, they usually will give you 30 days, and they want to hear back in writing that you have completed that. Remote participation, I talked about. Let's see. meeting minutes, the 3 meetings are 30 days. So that is what I have on the open meeting law. If you have any other questions, or I'll be around for a bit after if you think of something later, but I'll try to get in these last 2 laws so you can get out and enjoy this day. So next one, public records law. Again, applies to basically anyone who's got a position in the government, paid, unpaid, board, single officer. Public records, very broadly defined, books, papers, photographs, recordings, electronic data, doesn't matter what form it's in, that's either made or received by any officer or employee. So something you created in your office is going to be a public record. Something that somebody sent to you is also going to be a public record unless one of the exemptions applies. So it really looks at what's in this record rather than what format it is. Yes?
So if I read an analysis that was provided to my commission by another town employee, and that analysis was on the town website, and I read it, and I looked at it, and I thought about it, and I created a response to it, is that a record? I sent my response in an email to say the chair of my commission, is that then a record?
I would say it is. Yeah. And I was going to mention, actually, this is the right slide. Just one thing to keep in mind, I think that in town here, if you're on a board, do you get a town email address or not? No? Okay. So it's just something to keep in mind. I'll go back to 5-member board, 2 members emailing each other back and forth about something that's not an open meeting law violation because there's only 2 out of 5, no quorum. But if somebody makes a records request, maybe you made a decision and they didn't like it, and they say, I want all records from all these hearings, including any emails between any of the members that talked about this. You may have been emailing back and forth with your fellow board member on your personal, Gmail account or something. Strictly speaking, it was talking about town business, and that's covered by the public records law. And so we unfortunately have to tell people, that's a valid request. You need to come up with it. Some towns, they give all the board members a town, email address, and so you can kind of avoid having to get involved with your own email by using that. But just to keep in mind. Let's see. Text messages, the supervisor of public records who manages this law, they haven't really come out with any formal regulation or rule about these. Just like with an email, though, if you're texting back and forth on board business, technically that would be a public record. They're in sort of a strange area because after a certain period of time, I'm not sure what it is, but certainly a few weeks, they disappear from your phone. So, it's not that you destroyed it, it was just gone. So there isn't any hard and fast rule on that, but, just be aware, maybe try to avoid doing that so you don't have to worry about searching your phone if somebody makes a records request. So people make records requests to the town. They can make them in person. They can walk up to the counter and say, I want X, Y, and Z. A lot of times they come in writing, email, mail, fax. Those are all valid records requests that have to be honored. All towns under the records law now have to have a records access officer, RAO. She's sitting in the back there right now, Maureen. And so the RA, they created this position of RAO to try and centralize, when a request comes in, so you've got sort of a point person that gets it to the right place, reminds people that, the 10 days is almost up, answer questions, that kind of thing. And so the response, whether it's from the RAO or from the, the office administrator, whoever's going to do it, has to respond within 10 business days. So again, Saturdays, Sundays, legal holidays don't count. So it's 2 weeks. And that's a very important date for a couple of reasons. If if the request is very large, or for any reason you're not going to be able to provide the records within those 10 business days, you at least have to give a response and explain to the person making the requests that I can't give you everything I want, here's why. But, you know, again, stick to that. The most important thing is that particularly with large requests, they may be so big that, you know, the person who works in the office is going to have to spend 4 hours digging through files, searching emails, all sorts of things that you're going to want to charge a fee for. If you didn't give that written response within 10 business days, you're not allowed to assess a fee. So that's the big thing. A town can have more than one RAO. Sometimes, you know, the police department has their own because they deal with sort of different kinds of records, a lot of exemptions. The school department may have their own. But everybody's supposed to have at least one, just to assist requesters and try to make the things, you know, work smoothly. So your response within those 10 days, you want to confirm what the request was. If I'm helping with the response, I always either repeat it in the letter or attach the original request so nobody can say later, no, that's not what I asked for. You know, tell them if you think there's going to be records withheld because they're exempt for one reason or another. You know, tell them that ahead of time. Give a estimated fee if you don't know what it is exactly yet, and when the response is going to be, when you expect to be done with them, again, for these larger ones. I'm not going to go through this entirely, but a little more detail of what I just said. So you're supposed to respond within 10 business days. A lot of requests are pretty routine. You don't even need that. You make the copies and send them out, or you can do it by email if you've got things saved electronically, and you're done. If it's going to be longer than that and you're not going to have them even gathered and sorted through within 10 business days, you can take an extra 15 business days if you need to. You want to tell the person that you need to do that. You can't give yourself more than 25 business days if it's just an outrageous request, but that you're going to have to deal with it anyway. You can ask the supervisor of records office, explain why you need more. That's called a petition for more time, and they can grant it to you. You can also talk to the person making a request, saying, we're going to do the best we can. We only have a part-time person who can get this ready. You know, we're going to need more time. Is that okay with you? And if they say yes, you know, get it in writing so there's no dispute later. But that's okay as well. And again, the estimate on fees, well, it's going to take the staff person 4 hours to do this, and then there's copying time, et cetera. Figure out what the fee might be. A lot of times if it's a big request and you tell them it's going to cost them $150, suddenly the request gets narrower. So that's good for both sides, actually. So here's and this is in the supervisor's regulations about the days, requesting for more, confirm in writing if the requester has agreed to give you some more. Fees, if it's making paper copies of things, you can charge them 5 cents a page, which includes double-sided. Cost of mailing the response, if it's a big package. If it's a set of plans from the planning or building department, might need to send them out to get copied, you can charge them for that. Because Nantucket's population is under 20,000, any staff time that you want to charge them for, that all the time is available. Over 20,000 cities and towns, you can't charge for the first 2 hours. You also can only charge whatever the lowest hourly rate of the person capable of doing the search and preparation is, and that's capped at $25 an hour. But one thing important to remember is that, and again, this is particularly if it's a large request, you get your response ready, you tell them what the fee is going to be. You know, it's going to be $200 to get this ready for you. You send it to them. you don't have to start making the copies and getting them ready until you get that payment. Because it used to happen, or still does happen, that you tell them it's going to be $200 and, you know, weeks go by and you don't hear from them. You can hold back on actually getting the response ready and the records ready until you get that payment. There is an appeal process to the supervisor of records. Somebody made a request, either you told them they were exempt, or you told them some of them were exempt and not gonna produce them. Maybe they think, I expected 3 times more records than I got, I think they're holding out on me. They can appeal to the supervisor of public records. They do that in writing. The supervisor's office will look into it. They may give your office a call, find out, you know, what's behind this exemption that you asserted. So you may get a response from them saying, you've said you held this because these are Corey records, you know, criminal records. We don't think these fall under that statute, so you need to produce them. Or they may agree with what you said. A person who disagrees with the supervisor's office, they can go to Superior Court. Again, doesn't happen much. If the AG thinks that, if the supervisor thinks that they're being ignored by the town board or office, they can turn it over to the Attorney General's office to file a complaint against the town. The requester can also go directly to Superior Court. Again, it happens, but not much. The one sort of thing to keep in mind if you ever get into a large dispute about this, and hopefully we could help you out with this too, is that if a person goes to court saying the town is blatantly violating the public records law and didn't give me anything that I was entitled to, if the judge agrees with that, they are likely going to award the plaintiff attorney's fees, which means you not only have to turn over whatever the records were, you also have to pay their lawyer, and you don't want to do that. Let's see. In the supervisor's records, they have this list of things which state agencies are now required to put on their website. That has not trickled down to the cities and towns yet. They're just encouraged to do this. Licenses that were issued, annual reports, new regulations, hearing notices, all that kind of thing. The more you can put on your website, the better, because for a couple reasons. One, it just makes it easier for people to find and not even bother making a request. Also, if somebody makes a request saying, I want all the hearing notices from the planning and zoning boards for the last 2 years, if you can respond back to them and say, well, those are all on the town website, here's the link for each of those boards, and let them look them up and print them out if they want, that's a perfectly valid response. Let's see. Producing, this is not for things that are on the website, obviously, but you get requests for things that might include confidential information, attorney-client privilege correspondence from my office, things which may have persons, medical information. Maybe the Council on Aging has those kind of records, and you don't want to give those out. Things with Social Security numbers, bank account numbers. Maybe your file has a check that somebody paid a fee with. If that's part of the file, you should turn that over, but you'd want to blank out the check number, that sort of thing. So be careful in responding if you think there may be some confidential things there. If you're not sure if it's confidential or not, you could call the supervisor's office. They have staff attorneys, or you could check through the town manager's office with us as well. We help out with record responses a lot. And attorney-client privilege communications, that's if basically we were asked for an opinion and give it, and it was intended to be confidential. Usually it'll say, if it comes from our office, we always put confidential attorney-client privileged or confidential executive session material. We'll always put that in bold at the top so it's clear. The attorney-client privilege never expires, and that's a legitimate exemption to a records request. So that's public records. There certainly are more to it than that, but that's the requirements that you should keep in mind. Yes, Rick.
I think I saw you
Oh, no, no, I'm sorry, not the records requests.
I don't understand it. It just seems, every once in a while, I say, gee, I'm sort of curious, what are people asking for? And, so you can make a public records request to get copies of all the requests. I'm serious.
That would be a legitimate request. And
You have to get all the documents, you say, gee, I like number 6 and 5.
right, and I'm not sure, there's a big, long municipal records retention schedule that's on the Secretary of State's office. I'm not quite sure where record requests falls, but there's probably at least a year or so where you have to retain those, and so if somebody wants to see them, you can. I mean, if you wanted to put those on the website, there's nothing privileged about them, I don't see why you couldn't. But this was, these sorts of records are ones that, again, the supervisor says, we encourage you to put these on. One, it sort of is a public service. These are the kinds of things that people often want to see. And if you put them on the website, then you don't have to go through this whole record request, with all the details and requirements of that. You can just say, well, that's all on the website.
I agree, I think the town, actually, one of the things I've always been very pleased with the town, they have lots of access to records.
Yes.
I think we're generally very good at that. But it is interesting if this becomes more electronic, so you make a public records request and somebody does an electronic search of the town's electronic depository of records.
Mm-hmm.
They search by keywords or something, and that becomes the method of production. You sort of wonder about what happens to all those paper files that aren't in the electronic.
Yeah, well,
Is there a recommended way to go about that kind of thing?
Well, that raises a couple of things, thanks. If somebody makes a records request and they'd say, I'd like these records in electronic format if possible. If you already have them in electronic format, you're supposed to provide them that way. And that way, you're not really charging a fee as well. Obviously there's lots of things which aren't. There's still paper files in the file cabinet. If somebody says, I want this in electronic format, but they only exist in paper, you're never required to create a document in response. And so you're not required to get it electronically. You could do it if you want. Maybe scanning it in would be a good idea for you too. But you're not required to. And all those paper records, again, this municipal retention schedule, there are some things you have to keep forever. Meeting minutes, for example, you have to keep them forever. Certain things you have to keep for a year, 7 years. At that point, if you don't need them anymore and the retention period is gone, there's actually an office in the supervisor's office that says, I have the following records, I'd like to destroy them. And they'll write back, say, yep, they're past the deadline and you can destroy them if you want. It's discretionary call. Mm-hmm. So we'll do the conflict law last, conflict of interest law. This is General Laws 268A. Applies to all state, county, and municipal employees. The term is employees. However, the definition means it's more than just people who are hired by the town. It covers pretty much anybody. Any person performing services for holding an office, position, employment in a municipal agency by election, appointment, contract of hire, with or without compensation, full, regular, part-time, consultants, seasonal. It's just incredibly broad. Pretty much anybody who's doing anything for the town is covered by the conflict law. So it's always good to know at least the basics of it. It's very broad, as I say. It includes seasonal employees. It can also include if the planning board hires an engineer to do a peer review of some application. That may be a fairly limited thing, but for the period that engineer is doing that, they are a municipal employee because they're working for the planning board. So they have to be aware. That may limit what else they are able to do in town professionally. The special municipal employees, certain offices, and the select board has appointed a lot of things as specials. In order to be a special municipal employee, which has exemptions under two sections that I'll reference, it has to be designated by vote of the select board. If it's an unpaid position, that's always eligible. If it's a part-time paid position, it can't be paid for more than 800 hours a year, which is roughly 15 hours a week over the year. If it's less than that, they can be designated as a special. And as I say, it doesn't mean anything anywhere other than outside the conflict of interest law. But there are two sections where additional exemptions to avoid violation is available. And I'll just touch those briefly. Also defined in the law is immediate family. There's one section which says, don't participate in any matter in which you or your immediate family has a financial interest. So that includes you as the town official or employee, your spouse, and each of your parents, children, brothers, and sisters. So this does have sort of a funny way it works sometimes. If I'm sitting on a town board, I'm a municipal employee, my wife is part of my immediate family. Her brother, who's my brother-in-law, is covered by the immediate family because it's my spouse's brother. But if I have a sister, she's part of my immediate family. If she has a husband, he's not. He is not my sister and doesn't fall into that definition. So occasionally that makes a difference. You know, nieces, nephews, uncles, again, not part of your immediate family for purposes of this law. Disclosure, there are a lot of things that say it would be a violation of you to do something unless you file a particular disclosure with the town clerk or unless you file a disclosure with your appointing authority and get it approved. So that's very important. The State Ethics Commission, which oversees this law, interprets it and enforces it. They have a ton of different disclosure forms on their website, which are real easy to use. And they will usually need to get either filed, as I say, either with your appointing authority or with the town clerk's office. So we need to be aware of that. So one section which comes up a lot is section 23, the Code of Conduct. It has several pieces to it. Most of them really don't come up much, but these two do all the time. 23B2, it's a violation if a municipal employee uses or attempts to use their office to obtain for themselves or anyone else an unwarranted privilege of substantial value, which is defined as $50 or more, that's not properly available to similarly situated individuals. So in other words, using your office to kind of, give someone advance notice that something's going to be available, so they're the first one in the door. Getting anything, saying, I have this position with the town, so I want special treatment. Anything along those lines is improperly using your office. 23B3 is probably the one I talk about the most with people. It says a municipal employee may not act in a manner which would cause a reasonable person having knowledge of the relevant circumstances to conclude that they're acting with bias or favoritism, family relations, any personal reason as opposed to the best interest of the town. And so this is sort of a subjective standard. It's not whether you think what you're doing is going to look bad, but would a reasonable person who is aware of the facts, would they conclude it? But importantly, this section says it will be deemed an unreasonable conclusion if the employee has first filed a written disclosure of the facts, either with the appointing authority or if they're elected with the town clerk's office. And so, for example, if I sit on a board and my brother is applying for a variance or a permit of some kind, I can't sit on that because he's part of my immediate family. But if it's just my best friend for the last 20 years, and it's very well known in town that we're best friends, I might think, well, now he's applying for a permit. It's probably not going to look great if I participate in this. People might think, well, hey, I'm going to vote yes, he's my best friend. But I feel I can act objectively on this. I would probably want to file this written disclosure. I sit on board X. I'm getting an application from Joe Smith. He's been a personal acquaintance of mine for 20 years, but I'm going to act objectively on his application. I write that up. I file it with my appointing authority. That way, if anybody complains later that there was a violation of this section, it's not. It's just deemed legally not a violation. Just a couple of examples. Fundraising. Sometimes town departments, the library, fire department maybe, looking for donations to buy, equipment, anything like that. It's okay to do that. The Ethics Commission did come out with a decision saying you have to be careful not to trip over certain things. Any donations have to be handled through the gift account statute, means it goes through the treasurer's office, so there's a public record of it. Don't use any overt pressure, and sort of don't do any inherent pressure either with people you're asking for donations. Town employees who are involved in this fundraising at all have to be careful to treat everyone the same, and you're supposed to keep a list of names of people or businesses that maybe you solicited for this sort of voluntary donation. This decision talked about inherently coercive, soliciting someone who may be affected by a pending or anticipated decision of the municipality. And so an example, let's say not to throw the fire department under the bus, but say they want to conduct some sort of fundraising thing of any kind, and they solicit someone in the fall, a business or a warehouse owner or something like that, saying, would you like to make a donation to this? Well, if they then say, we'd like you to make a donation to this, and by the way, in 2 months, we need to sign off on your annual fire safety decision. Well, that would be overtly improper. But if this thing from the Ethics Commission warned that even if it's inherent, the person is going to feel like, well, I know they're going to be looking at my building in 2 months, so geez, maybe I should make a $100 donation to make sure that it doesn't get held against me. At least arguably, that would be an issue under this too. And that would be considered, if it's bad enough anyway, that would be considered by ethics as a violation of 23B2, improperly using your office to gain an unwarranted privilege. And so, if you're involved in that, be aware of who you're dealing with. This is a very specific one, but it says if a town official, let's say somebody asks the town manager for an employment recommendation. If it's somebody who used to work under the town manager, she can do that on town letterhead. It makes perfect sense, former employee. If it's someone else that she knows, and somebody asks for a recommendation, she can do it, but not supposed to use the town letterhead. Again, they're sort of using your office to give a little more, importance to the recommendation, perhaps, arguably anyway. And not supposed to do it for immediate family members, again, using your office. Gifts, this is Section 3 of the conflict law. Section 2 of the conflict law says you can't accept a gift of any value if it's offered with corrupt intent. So that would be a bribe, please do this for me, I'll give you $1,000. Obviously, you're not allowed to do that. But even if it doesn't have that bad intent behind it, but they give you a gift, they want to give you a gift for or because of some official act that you performed or that you're going to perform with your official capacity. If it's worth $50 or more, it's going to be subject to this regulation. Some gifts are exempt. Somebody knows, you're the building commissioner, and somebody knows you from professional dealings, but they want to give you a birthday present just because they think you're a good guy. That's okay. That wasn't given because of some permit that you signed off on. So that's entirely unrelated to your office. If it's given and it is related to your office, and you have to look at this $50 business. So again, using the building inspector or commissioner, they helped out a lot with this complicated building project that went on, and as a gesture of goodwill, the builder at the end wants to give a $40 bottle of wine or a gift card or something to the building commissioner just to say thanks. It's not illegal, If it's worth less than $50, there is a disclosure form, however, that the building inspector is supposed to fill out and file with their appointing authority. If it's worth more than $50, they need to say no. That's the substantial value cutoff. If it's being offered to you because of something you did or you're going to be asked to do in the near future, that would be considered a violation of Section 3. If you get this gift, again, this written disclosure, it may cover you, but you might also want to file a disclosure under the appearance section, 23B3. And again, you go to your appointing authority or the town clerk if you don't have one. Yes?
I have a question. The training that we took, was it last year online about some
Yep.
of these things?
Yeah.
There was an example, like if someone gives you a gift basket or something that is obviously worth more than $50, and it was addressed to you, but you're part of a board, that if you write a disclosure and say that the whole entire board ate up the gift basket,
Yeah.
that was all right.
Yes, I would say that's fine too.
And so,
Yeah.
if a gift, because sometimes it's, people usually give those kind of things as oh, thank you so much for
Yeah.
what
Mhm.
y'all did, and they don't know the names maybe of the other board members. but they
Right.
know You're part of the board and you help.
Yeah, I'd say
Is it
that's,
better to say, thanks, but we can't accept the banana bread you made and all the other,
Right.
stuff in here, and make them take it back, or is it better
I think it's more if you,
I'll
yeah.
accept it for my entire board, and then you write a disclosure?
Yeah, I think that would be fine. Yeah, you're right. A $100
Right.
fruit basket. If you keep that in your office and anybody in town hall passes through can have it, can share in it.
Because on Nantucket, a $50 gift basket doesn't have much in it.
This is true. And so you sort of look at the intent, if somebody says, well, you helped me out a lot. I want to say thank you to you. Here's this $100 gift card. That you should give back. But yeah, if you can sort of make it a department gift, more or less, then that should be okay. There's a lot of other examples of these gifts, which I won't go over all of them. Some of them, travel expenses, sometimes a vendor who wants to sell the town an expensive piece of equipment, and they say, well, our office is in Springfield. Can we fly you out to look at this, and then we can answer your questions? If it's legitimate job-related expense, you can do that. You certainly have to file a disclosure, but that wouldn't be considered an improper gift if it's for that. Free golf at some conference, so that's probably a little riskier. Getting free admittance to some sort of training event, again, legitimate public purpose, is generally not going to be a problem. Going to some conference that's related to your office. A couple of specific sections. Section 17 has two parts to it. You can't receive compensation from anyone other than the town, or act as an agent or attorney for anyone other than the town with regard to any particular matter which the town is a party or has a direct and substantial interest. And so the purpose of this is so you're not kind of serving two masters. If you're a town official, you should be only acting in the town's best interest, not to, give favor for somebody who's paying you on the side or who you are, sort of a formal agent for. If, let's just using me as an example, I'm an attorney. If I sit on the planning board, I am not allowed to represent any clients before any other town board. That's acting as an agent. For special municipal employees, if I'm a special employee on the planning board, I can never represent a client before the planning board, but I actually could go represent them before the select board or the school committee. Special employees just aren't allowed to kind of work both sides of the table. Acting as an agent under Section 17, that can be sometimes very formal. You hire an attorney, they're formally your representative, but it can be a lot more informal as well. If you're acting as a go-between between someone in town, trying to help them negotiate all the departments in town hall they want to talk to, so you do all the talking on their behalf. That's acting as an agent. acting as a liaison. Serving as a spokesperson, you get up at a select board meeting about some controversial issue and say, you know, I live in this neighborhood and I'm talking as represent all my neighbors in that neighborhood. Here's our concerns. That can even be considered acting as an agent. If you're in that position, you can work with the group behind the scenes, but then have somebody else get up and do the talking at that meeting. You can't, however, always advocate for yourself. You own property, you get a tax bill, you think it's too high, you want to apply for an abatement to the assessors. You can do that. You're not acting as an agent for someone else, you're acting as an agent for yourself. Another section which comes up all the time, section 19. As I mentioned, you can't participate in your official capacity in any matter in which you, your immediate family member, or your business or employer has a financial interest. This doesn't care if you're a special employee or not. It applies to everybody. It also doesn't care what the size of the financial interest is. It can be large, it can be small, it can even be negative. That's still something which you're supposed to recuse yourself. You know, walk away from the table for, find somebody else to handle it. There is one exemption which applies to appointed officials. Again, something gets filed. It's an application. My brother has an interest in the party. I'd like to be able to sit. I think I can do it objectively. I can fill out a disclosure to give it to my appointing authority. If they sign off saying, yes, I agree, you know, I trust that you're not going to, you know, act impartially, I'm sorry, act with favoritism on this. If they sign off on that, then I can participate. That disclosure will be a public record so I can prove that I did it. It is a discretionary call for the appointing authority, however. They might decide, no, this is not going to look good. I'm not going to sign this for you. Yes?
Well, just to go back to the prior section,
Yep.
you know, in this town, we got an awful lot of real estate related activities and professionals,
Right.
lawyers, surveyors, realtors, and there's a difference, I gather you're saying, between special municipal and non-special municipal in their ability to represent clients before boards.
That's right.
And
Yeah.
so is there an example of someone who's not a special municipal employee? And I assume that if there are such, the prohibition is sort of absolute, I guess?
Yeah, well, if they're an attorney that happens to have a position and they're not a special, and haven't been designated as a special, if they are actually, the Ethics Commission says that a professional engineer, they prepare a plan for somebody and they put their stamp on it and that gets filed with the town, they're basically acting as an agent for the property owner. You know, that also can be a problem. And so, you know, it may be that they have a town position that's not even eligible for special employee designation, in which case, you know, that's a problem, honestly. If they serve on a board that can be, they really should ask the select board, if they're not already, to designate them as special, so they're allowed to do things for every other department, just not the one they sit on. Yes?
So, the board I sit on, we have 2 attorneys, architect, another designer who also does permitting, builder, real estate, and whatever. The people, so when we have an application before us and say the architect is working for the homeowner, they get up, they leave the room while we deliberate
Yeah.
and vote. Is that sufficient? Or
Well,
is there-
that-
We're special.
Oh, I see. Yeah. Yeah, I think the way that would play out, by getting up and leaving the room, they're covering themselves under Section 19. They're not participating in a matter in which they have a financial interest or their business. And under 17, if they're a special, they can't, sit across the other side of the table and represent that party in front of their own board.
Right, so we have.
But if they-
recently, we're one of the people on the board, and they were asking, should we leave the room or should I be available for questions? And I said, I think you should leave the room.
Yeah. Yeah, Section 19 is very strict that way. And so, hopefully, most of the time anyway, they can avoid this agency question by,
And it's
yeah.
not their whole firm, it's just that individual.
Yeah, yes, that's right.
For attorneys, though, is it your whole firm?
Well, because it's, under section 19, that would apply to the whole firm. You can't act on something which you or your business or employer has a financial interest.
So
But that, by leaving the room, you avoid violating section 19.
So my firm, if I get up and I leave the room, my firm's representing an application, which doesn't really happen, but if my firm is representing the cover.
Yeah, in general, that's true. If, it can get a little dicey if you've, because this agency business, maybe you can, if you know it's gonna come before your board, maybe you can have somebody in your office kind of handle everything like that, but.
And then, sorry, just to stay on.
Uh-huh.
And then what happens for any one of us when, say, we aren't, like, sometimes, different people in your office are doing different things. What happens when, like, if you get an agenda and you realize, if it becomes apparent sort of later in the process, like, you don't know that it's either coming before the board or, I don't know how that would come up, but like, if you suddenly become aware,
Yeah.
I think this is a conflict or I should be out of here.
Yeah, I mean, sort of using that example, if your board hasn't dealt with it yet, then you wouldn't have participated in that matter. And yeah, sometimes they do kind of spring up later without knowing it. But it's, section 19 is saying, that someone acts with knowledge on something in which they or their employer have a financial interest. So as long as you didn't know it was going to be coming your way,
And then would you file one of those disclosures, just saying this came up, I got him out the room as soon as I became.
you could either, you could either just leave the room, because then you're not participating, you could file a disclosure just in case you're sort of worried about the appearance. And then the other option is if you're appointed, you could actually apply to your appointing authority and say, I'd like to participate in this anyway, if you'll allow me to, I will act objectively. So that's different ways maybe to approach that. Rick, still?
So just to try and clarify again, the special versus non-special.
Mm-hmm.
So if an attorney or a surveyor or realtor was a member of a board that was not a special municipal employee,
Mm-hmm.
they cannot represent clients before any other board in the town. Do I have that right?
You do have that right. I should add also, maybe I forget if I mentioned this or not, but the Ethics Commission actually encourages, select boards and city councils to designate any eligible position as a special, just to help people, because, you end up losing good people if they're going to have to turn down work.
Well, that's what I'm trying to understand.
Yeah,
because
yeah.
Lots and lots of people out there
Right,
could be involved in that.
right. But, the way Section 17 is written, that's the way it works. And so the more special employee, the more they can be special employees, the less they have to worry about, either violating the law or having to resign their town position. Both of those are bad results. So, yeah, that is what it says. Section 20 is kind of the most complicated, so I don't spend a heck of a lot of time on it. But it really depends on the facts. What it says at the beginning is a municipal employee may not have a financial interest in a contract with the town. And that could be one, maybe I have a business that sells cleaning supplies. If I put a bid in to sell cleaning supplies to the school department and I get it, well, now I have a contract with the town, so that's a problem, unless I get an exemption. Also, if I have one position in town and I want to get hired as a second position that's compensated, that's also a contract with the town. So there are a lot of different exemptions. There are two that apply to special employees, a little easier to get. Special employee picks up a paid position in a different office, all they have to do is file a disclosure. If it's in their same department, they need to get the select board to sign off on it. If this new paid position is a part-time or call firefighter, with maybe a special police officer, that sort of thing, they need to file a disclosure and get the select board to approve it, but that's relatively easy to do as well, because you want people to volunteer for those sorts of things. If the contract is some sort of housing subsidy, which, the town manages the funds and gives them to the property owner, it's technically a contract, but there's an exemption for that. So there are it really depends on the facts of each situation. If you are a municipal employee and not a special municipal employee, there is an exemption. It just has a whole bunch of different parts to it. It has to be with a different department than the one that your town office is in. It has to have been made after being made available to the public, whether that's publication or, public bidding sometimes. If you get that contract, you have to file a written disclosure. If it's for personal services, in other words, it's another position rather than selling goods, this new position you have that's compensated has to be outside the normal hours of your first office. You can't get paid for more than 500 hours, so that's in a year, so that's fairly limited. It's about 10 hours a week. The head of the agency has to sign off that, yes, this is an actual job. It's not a phantom job that I created to, give to this person. And the select board has to approve it. So that, in a nutshell, obviously the conflict law can be a lot more complicated, but as I say, it really is case-by-case basis, and you could either get an opinion from our office through the town manager's office. I write tons of those. You can also call the Ethics Commission. They have a legal division with staff attorneys and attorneys of the day, and they're very good about calling you back and helping you sort through these questions. These are just some of the websites. The open meeting law, again, is under the Attorney General's office. You can find a lot of information on their website. Public records law is out of the Secretary of the Commonwealth's office. They also have a fairly lengthy guide to the public records law, which is useful. Conflict of interest is State Ethics Commission. They don't have, it's the way it applies so differently to different people. They don't have a little handy guide like this, but they do have a lot of different things. They have a sort of a handout for select boards, school committee members, conservation commissioners, so, you can sort of streamline what you're looking for. And they also have, legal staff you can call up and ask. So that brings me to the end. I'll stick around for a little bit if you, want to follow up with anything, but otherwise, I appreciate you guys coming out. Hopefully you got something out of this, and thanks very much. Sure.
I'm Karen Williams.
Yeah. Okay. Okay. Is it a full-time position? Okay, so the way that would work is in both of those boards, you're already a municipal employee under the conflict law, okay? So if you get hired, you now have a contract with the town. And so, that last one I talked about, the regular employee, you either have to meet all of that, well, actually, you have to pay for more than 500 hours, so that wouldn't apply. So the way around it would be, if your boards, you have to do both of them, are special municipal employees.
So what would I have to do, tell the boards I need to?
Either, well, look it up, there's actually, the select board has a list of ones that are already designated as specialists. So, see, if you're on that list, then you don't have to worry about it. If they're not, you would have to ask the board to take that vote. And they could.
To make me.
To make the board, it would apply to the whole board, not just you, okay? But then if you did that, then you could probably just file a disclosure, I've been hired for this position in the planning office, file it with the town clerk, and that usually will take care of it.
And my other real quick question
Mhm.
I'm on NRTA board, and I'm also on Commission for Disability.
Okay.
The
Oh.
the selection.
Okay, but you're considered,
We're a board for the NRTA.
okay,
And I don't know why this happens or how, but it's the selectmen and me.
Hmm.
That is the board for the
Okay.
NRTA. And because they're all the selectmen except me, we always have our meetings together. So it's like
Yeah.
the NRTA has a meeting, and then I'm told, okay, leave. And then, so they don't have to go to two different meetings. They're
Yeah.
sitting here already
right.
for a selectmen
Okay.
meeting, and they have our meeting first.
So that, yeah, so that's open meeting law issue.
But so
They
because
could-
of that,
Mhm.
like, we can never have executive session, because the NRTA board has their meeting first, and there's a room full of people, and so it's like I've been told in the past, well, no, we can't have executive
Well,
session, because we got all these people here, we need to hurry up, we're about to have a
Oh,
selectmen meeting.
well, I mean, that wouldn't be why you can't have executive session, but if the NRTA wanted to hold executive session, you'd have to fall under
Tell
one of those,
everybody to
well, you have to
leave.
fall under those 10 purposes. Yeah, boards do it different. Sometimes they say, we're gonna have a half-hour executive session, so we're gonna go to the room across the hall, and then we'll come back.
We should still be having meeting minutes and stuff like that. right?
Yes.
I don't know.
As far as posting an agenda, you could probably do it on one agenda, meeting of the NRTA at 6, and
Well, I
select
mean,
board at
the
7 or
head
something.
of the NRTA, she sends out the agenda, like email. I mean, we never have hard copy of it, but
Yeah.
it's over email. But then, I don't think we ever review minutes like from the last meeting, so critical, all that kind of
If
stuff.
they're considered,
And
mean,
Congress does.
if you're considered a separate board, it's not just sort of a subcommittee of
But
the
they're not,
selectmen.
do they have different guidelines because they're not technically part of the town, the NRTA?
Is that, you talking regional transit? Is that-
Uh-huh.
Okay. Well,
Do they
there's
not
there's
have to
still,
comply with the same things?
no, they still have to comply with the
they
open
do?
meeting
Okay.
law, yeah.
Well, then I have
So
to
wh- so whether it,
research the- I just wanna make sure.
whether
we
it's sort of
comply.
one set of minutes that covers what both, boards did, I think that's okay. And if it's one agenda that says, NRTA meeting at 6, so select board at
Right.
6:30, then
That's
then you're
okay.
covering the, yeah. So you could
Okay.
kind of do it together, but the NRTA would be subject to the open meeting law, I would say. So, posting and minutes are the two big things,
Okay,
yeah.
great. Thank
Okay.
you so much.
Sure.
Thank you, Sid. It's very helpful. I keep getting lost in the thickets of the subcommittee stuff.
That's okay. She looks familiar.
Maureen.
I know, Coleman.
Yeah, she is manager of the public rights, and I understand that. It's very virtual, very virtuous.
I think that person's here also. Maureen Coleman, you never remembered me. I don't know why I remember your name.
So a
It was
subcommittee
your first day
is
or
a
your
group of
first
people,
week
but
that I
yes,
met you.
if the commission is 7 people, the subcommittee is
Because
3.
you had a big.
Mhm.
It's not
Discussion.
or all by
If
itself.
it's not a,
Coleman,
right,
Congan
it's not a
Coleman?
quorum,
Yeah,
okay, that's why,
Whatever.
it sort of
Well,
seems
you know
like,
what, just-
I try to
you
push the
don't have
envelope
to
where I
say you're
can.
not, and it
That's why I say if a 7-member board,
Yes, my name
and
is
3 of
Coleman.
you,
Yeah,
meet
right
at
that
the coffee
way.
shop and say, why don't we put our heads together and kind of
So
come up
you
with a
have to
memo
keep up with all
to
these,
talk about
you
the
have
next
to know
meeting.
all these laws.
I would say that's not a subcommittee,
What
you
you
weren't
can hand out,
delegated to
what
do
you
something.
can't hand out.
So I think that's okay.
Right.
But
So
if,
we are delegated.
if you are delegated, yep,
So, yeah, we're out there looking at something that subcommittee is supposed to do. I get that the public might want to be interested in that, and come to the subcommittee around looking at whatever we're supposed to be looking at.
Oh, they do.
And we have to talk about what we're looking at, we can't go around like,
well, right,
we can't say a word about this horrible thing we're looking at that we have an opinion about.
yeah.
And then we go back and we think about it, and we have an opinion, and we wanna talk to each other, 3 of us, about this opinion that these opinions that we're coming to.
Well, what,
And all these different boards.
I always bring your things down. Well, what the AG would say is that if you can delegate, as a group of 3, you can delegate to do something and report back, you are a subcommittee in the law, so you need to post your meeting and take minutes and allow the public to be there. Now, if you're doing an on-site inspection, you're walking the entire property, exceptions and definitions of
Yeah.
meeting.
Yeah.
So you're a subcommittee, but you're not holding a meeting technically. So, you know, I mean, I have to say, you're not supposed to deliberate. I mean, if you're walking into the property and you wanna ask questions and stuff, yeah, I know. But you don't, what you really wanna avoid is to show up at the main board meeting and say, well, we walked the property and we decided while we were walking around that, that we're in favor of this.
Wonderful.
That could be, well, you guys made a decision, the public wasn't there.
We didn't say we decided, we said, we looked at this, and it occurred to us that this is something we have to consider in this.
Yeah, probably my best
This is an
advice.
issue that
Yeah.
should be addressed by this commission, because it's within our purview. And in talking
Yeah.
about it now, at an open meeting, this is not feeling about.
Yeah, I mean, my best advice to that, if you are gonna be considered a subcommittee, would be to, go do the site visit, which is not, schedule your meeting for a half hour, a meeting of the subcommittee for a half hour later, post it, well, there are no one's gonna come anyway, but at least you comply. Make your, decide what your recommendation is gonna be, sure, describe what your recommendation is gonna be, and then when the main board has a
Right,
meeting,
right.
you can say, we did this, here's our conclusion.
And then here's the other issue, this is the other thing that occurred to me, we get as part of this subcommittee, we got this document, and the document was produced by the state. I looked at this document, I'm a lawyer, and I looked at this document analytically, and oh my God, we've got this document that proves X, and based on proving X, we're gonna do Y, and it's totally different, and they're doing Y because they have the funding, and they have, that's what they're gonna do, and it's this horrible result. So I write to, luckily, one person, the chair, saying, look at this, they proved X, they're gonna do Y, it's awful. So I do this from my email address, because I don't have a government email,
Yeah.
so my email address, so that is potentially a public record. But in the meantime, it's not a, it's not a decision of the subcommittee. And she didn't circulate it as far as I know, the rest of the subcommittee, she used it as part of her report that she's gonna issue related to this particular issue about roads and
And
signage.
if you sent that to the chair and expressed an opinion like that, as long as you copy a quorum,
Right.
that's still not an email.
I ordered that copy of the subcommittee. I didn't, doesn't happen.
It's just.
You're gonna hate this answer.
And it's not.
That wasn't the quorum of the parent board, so that's okay, but it was a quorum of the subcommittee.
I didn't, I don't think I did.
And so that's why I tell people, if you've got something you want the board or something that you talk about, send it to them, or let's talk about this in our next meeting. And leave it at that. And then when the meeting starts, you can say, this is why